Today, we're diving into a really fascinating and honestly pretty mind-bending legal theory from an article by Leehi Yona called Whiteness at Work. It basically asks us to hit the reset button on how we think about workplace discrimination by asking one simple but very provocative question. So let's just start right there with a question that might stop you in your tracks. Can a white person racially discriminate against another white person? Now, your first thought might be, no, that doesn't make sense. But the law here is way more complicated than you'd think. And when you start to pull it apart, it tells you a whole lot about our legal system. To really get our heads around this, we first need to look at what the author says is a major blind spot in our current anti-discrimination laws. Okay, so here's the key. Title VII of the Civil Rights Act already gets that discrimination can happen within a group. The law totally understands that a woman can discriminate against another woman, a black person against another black person. Heck, a man can even be legally harassed by other men for not being manly enough. The courts have recognized all of that. But when it's a white person discriminating against another white person on the basis of race, all of a sudden things get really foggy. It's this giant under-theorized gap. So why this particular blind spot? Well, the author argues it's because the law has a hard time even seeing whiteness as a race in the first place. The author calls this the deracialization of whiteness. What that means is our legal system often treats white as the invisible default setting. It's the neutral baseline that all other races are measured against. But think about that for a second. If whiteness is legally invisible, how on earth is a court supposed to recognize when someone is being punished for not performing their whiteness correctly?
And the author, Leehi Yona, puts it so well here. Whiteness's privilege of invisibility prevents courts from recognizing whiteness as a racial category that polices itself. In other words, the very thing that makes whiteness the unspoken standard is also the thing that hides this form of discrimination in plain sight. Now, there is one little corner of the law where this does come up, but the author argues the way we handle it is so flawed, it actually makes the core problem even worse.
It's something called associational discrimination. This is when a white person faces discrimination because of their connection to a person of color. A classic example would be getting fired for having a black spouse. The courts do recognize that as illegal. But here's the critical flaw the author points out. This legal argument only works because a person of color is part of the equation. The discrimination against the white person is only visible to the court because it's kind of reflected off a non-white person, and that just reinforces the whole problem, this idea that whiteness by itself can't be the target of racial discrimination.
Okay, so if the current system is flawed because it can't really see whiteness, what's the solution? This is where the author proposes a really clever shift in thinking, borrowing a legal tool from a totally different area, the stereotype doctrine. And this brings us right back to the central puzzle. How can you equip the law to see racial discrimination when everyone involved in the conflict is white? Well, the author says we should use a tool that's already proven to work somewhere else.
And that tool is the stereotype doctrine. Basically, it says you're not allowed to discriminate against someone just because they don't fit the stereotypes of their group. It shifts the legal focus away from who you are and onto the biased ideas being used against you. The author makes a brilliant analogy here with gender discrimination. We already have well-established laws against harassing a man for not being manly enough. We call that illegal sex discrimination because it's about policing gender stereotypes. So the author asks this really simple, elegant question. If it's illegal to police gender stereotypes, why should it be legal to police racial ones? This would allow a white person to argue they were discriminated against for not being perceived as white enough. Okay, so that's the theory, but let's make this more concrete. What does this policing of white identity actually look like in a real workplace? The author gives a very powerful and historically grounded example: discrimination that targets poor, rural white people. Now, the argument here is that this isn't just about classism. It's about what's seen as a failed performance of whiteness. Think about the specific stereotypes used: lazy, dirty, immoral, unproductive. These are all traits that have historically been set up as the exact opposite of the so-called proper or acceptable norms of whiteness. So when an employer acts on these stereotypes, they're not just discriminating based on class. They are, in effect, policing the very boundaries of what it means to be white. So why does all this matter? I mean, is this just about expanding legal rights for one particular group? Well, according to the author, the goal is actually much, much bigger than that, with huge implications for how we fight all kinds of discrimination.
The author is really clear that making whiteness legally visible isn't meant to take focus away from the struggles of racial minorities. It's actually the opposite. It's about finally dismantling this broken idea of whiteness as a neutral, invisible default. By exposing the rules and the mechanics of whiteness itself, the argument goes, we can actually strengthen the fight against all forms of racial injustice.
So here's how this new framework could help everyone. First, it makes whiteness visible as a racial category, with its own set of rules that are policed. Second, it stops employers from getting a free pass for behavior that currently flies under the radar. Third, it directly challenges the architecture of white supremacy by showing all the work that goes into maintaining it. And finally, by giving this type of grievance a proper legal name, it could help redirect claims that might otherwise get mislabeled as reverse racism, which ultimately helps racial minorities.
And this all leaves us with one last big thought to chew on. This whole theory suggests that discrimination isn't just about what group you belong to, but about how you perform your membership in that group. So if the rules of race can be policed just like the rules of gender, it really makes you wonder, what other invisible lines and unspoken stereotypes are shaping our world? And what other kinds of discrimination are we still completely failing to see?